The HR Stories podcast is brought to you by the team at HR Stories. The team at HR Stories helps businesses and nonprofits better manage the employee experience, providing the tools, training, and resources they need to take their organization to the next level. Each week on the HR Stories podcast, management and HR consultants John Thalheimer and Chuck Simikian dive into the stories that matter to small business owners, nonprofit leaders, and HR professionals. We continue to be amazed at how companies allow poor decision-making, lack of knowledge, or in some cases, hubris to cause harm to their organizations. Each week, we discuss stories where companies must pay large fines, lose great talents, and even stain their reputation within the community. And then we tell you how to avoid the same fate. Welcome to the HR Stories podcast, where there is a lesson in every story. Welcome back to HR Stories podcast. My name is John Thalheimer. I am here with my co-host, Chuck Simikian. Good morning, Chuck.
Good morning. Good morning, John.
Maybe it's not morning. Maybe people are listening to this in the afternoon. That's kind of crazy, huh?
Yeah, we're 24 hours a day, 7 days a week, 365 on your favorite podcast player.
Well, this is it, Chuck. I told you it was going to happen again. This is the employee edition of HR Stories. We're going to title it, We Are All Employees. So it's that time again, Chuck. Employees are going to take over the airwaves. On today's show, we are going to talk about employees' rights. But before we begin, let's talk about what's happening in the HR news.
Yeah. So I will tell you before I get into the news, I love the employee editions that we do for HR Stories podcast. We did this once before. We're doing it this week, and we've got future episodes where we kind of turn the tables a little bit. So it's just kind of fun to do. But what's happening?
But I think also, I mean, it is fun to do, and I love doing it as well. And I'm glad you've come to my seeing of how important this is. But I also think it's important for HR professionals to understand the rights that their employees have, so they can make better decisions in their policies and procedures as well. Absolutely.
I mean, we're going to talk about some things that some folks may not think about, and those are they could be hidden landmines in a way. So
yeah, absolutely.
Yeah, but in in the news, I-9s are happening. They continue to happening over the last few weeks, the last months. The news has been rolling out about I-9s, and as a reminder, we may need to make sure you are using the new I-9s. There is a transition time period. I believe you can use the old I-9s until October 31st, but you need to start using the new I-9s as of August 1st, I believe. But I love the webinar that you did on that, John, just a few weeks ago. Lots of great information. And if you're interested, our listeners, if you are interested in getting the recording, there is a way to do that. Let us know.
Yeah, we can definitely get you that recording. And just to clarify, there is a new, as of August 1st, 2023, the United States Citizen and Immigration Service issued a new I-9. If you haven't looked at it, you may want to look at it because it is different. It is not your grandmother's I-9. It is different for sure. And so you definitely want to check it out. We did a great podcast. Chuck hosted and I facilitated around the I-9s. So if you go to our page, webpage, team at hrstories.com, go there, and on the right-hand corner, you'll see one that's a link that says workshops. Go there and you will see the on-demand recording. You can just kind of download it and listen to it there for yourself. So you may want to check that out and do that as well. But before you go anywhere, there's other things happening in the news. What else is going on, Chuck?
Well, I did come across something, and it does play into our story today about employee rights. And did you hear that music played at work over, let's say, the speakers at work or in someone's cubicle can constitute discrimination based on sex?
I kind of knew that, and I think we talked about it in one of our stories as one of the things that the complainant was talking about, but I want to hear more. What's going on?
Yeah, so this summer, just a few weeks ago, the U.S. Court of Appeals for the Ninth Circuit ruled that music that is sexually derogatory and has violent content played constantly and publicly, and that's the key, constantly and publicly throughout the workplace, can foster a hostile or abusive environment. This is a story out of Reno, Nevada, and the plaintiffs in this case were 8 former employees, 7 women and 1 man, and they worked for an apparel manufacturer called S&S Apparel. And they said S&S allowed the managers and employees to play sexually graphic and violently misogynistic music. Those are quotes from the lawsuit, by the way. This type of music throughout the warehouse on a routine basis. And the plaintiffs said some of the songs used terms like hose and, well, just other nasty words that I don't know if we should talk about here, but it glorified prostitution, extreme violence against women. And here's the interesting thing is both male and females complained daily, but guess what the company did? Nothing.
What did they do? Oh my gosh. What did they do,
Nothing.
Chuck?
Nothing. In fact, here's the funny thing is, and this is from the lawsuit, they defended the music as motivational.
Oh man. Choices, people. Choices. Gotta make the right choices. All right, let me guess, Chuck, that this has something to do with severe and pervasive standard must come into play here, right? A one-time song that may have been offensive may not necessarily have risen to the legal standard of sexual harassment. Am I on the right path here?
Yes, exactly. In this case, according to the court ruling, the music overpowered the operational background noise and was nearly impossible to escape. So, if someone played a song on, they have their radio on or their whatever, and all of a sudden an explicit song comes on and someone say, you shouldn't really do that. That's not going to rise to the level of any type of harassment or sexual harassment. But there were 2 key findings here. Number 1 was harassment can give rise to a Title VII claim, even if it's not targeted at a specific person, which we've kind of talked, there's a version of third-party harassment. And the fact that this conduct offends, this is the interesting, multiple genders does not automatically bar Title VII liability. And what we mean by that is, that was one of the defenses that the company used. They said, well, everyone's offended, so therefore no one should be offended.
Yeah, that's interesting, right? Because they're saying like, well, both male and female were complaining about it, so how can it be sexual discrimination? Wow, that's interesting.
Yeah. So I thought it was a good story example for our topic today.
Yeah, it's interesting, right? I think it is a good topic. And again, we do have rights. We may not have the right to choose the music that we're listening to in the workplace. I always frustrated me when in the workplace, like October, they started playing Christmas music, right? And it was just too early. It was just too early for holiday music. And so we don't have that right, but we do have a right to not have to deal with, and what was the quote you used? Sexually graphic and violently I can't even pronounce the word.
Misogynistic.
Right? Misogynistic, right? And so that makes so much sense. Oh my goodness. I do have another story, Chuck, that I want to share before we dive into the employee rights. Because I think it's important, especially now we're in August, and we have been dealing with extreme heat across the country. I think it's hitting almost every single part of the country. And so a couple weeks ago, President Joe Biden announced plans to increase protections for workers facing extreme heat as temperatures across the United States soar and large swaths of the country face heat advisories, right? And so we know that heat is the number one weather condition of killing people in the United States, more so than tornadoes and hurricanes, because it just happens, right? And it happens everywhere, and it's really hard to get out of that. And not everyone has access to air conditioning and cooling and that kind of stuff. And so what Biden has asked the U.S. Department of Labor to do is issue its first hazard alert for heat, which will give employers information on how to protect workers and inform workers on their right under federal law. And so again, really, they're going to put some standards in on how we should be treating our employees. I think at this point, we should know how. If we have employees working outside and it's hot, we need to make sure that we're addressing that, making sure they have enough water, making sure they have enough breaks, making sure they have shade. That should be all of our things. And that's outside. The other side of that is extreme cold weather as well, right? And making sure that we're making sure our employees have what they need to stay warm as well. Again, right, it just goes back to that general clause of OSHA where we are responsible to make sure that our workplace is free from recognized hazards that may cause serious harm or death in the workplace. And I would say heat and extreme cold are also both of those recognized hazards. So I think that's a big kind of topic that we should be definitely delving into for sure.
It's huge, and I've seen a number of the OSHA Quick Takes newsletter. Department of Labor has come out, and that has been a theme for many of their communications. So great.
I'm laughing though, and this is me laughing aside though. I think it's funny, right? Because my expectation is the Department of Labor is going to take some time to do this, right? They're not going to just come out and go, okay, here's the new standards. They're probably going to talk to the CDC, other health agencies, and it'll probably be released in the middle of winter. So I think in the meantime, we got to start taking care of our employees in there.
Exactly. So where do you want to go? You want to take a break now, John, or do you want to dive right into the story?
Well, I think that's really up to Samantha, but she's looking over my shoulder, and I think she's saying that we need to get to a break. The story's going to be long. We may need to take another break in the story, but let's take our first break, and then we'll come back, and we'll start talking about employee rights and what employees need to know and what they should do to protect those rights.
I love it. Folks, you've been listening to the HR Stories podcast where there's a lesson in every story. We'll see you on the other side of this quick break. Hey everybody, it's Chuck with the team at HR Stories. The HR Stories podcast provides weekly lessons along with compelling HR news in a storytelling format, but we have found our listeners want more. We know it's easy to be overwhelmed managing the day-to-day responsibilities of HR. We know HR can be isolating, and our listeners want a supportive community to turn to for advice and inspiration. And we've been there. We know what it's like. And that's why John and I at the team at HR Stories have created a membership program that goes beyond the HR Stories podcast. Imagine an education support group for new and experienced HR professionals alike, with twice monthly sessions and an opportunity to collaborate and network with your peers. Whether you are an HR team of one or you have HR as a responsibility, our membership program is designed to offer benefits that will elevate your knowledge and advance your career. Simply go to team@hrstories.com and click on the membership link in the top menu bar to learn more, or check out the link in the show notes below. You've been listening to the HR Stories podcast, where there's a lesson in every story. Today's theme is employee rights. We are all employees, and I'm excited to dive into this story today. So, John, it's all yours.
That's great. Thank you for that great introduction coming back, right? And one of the things I want us all to remember, HR professionals are employees as well.
Oh, yeah. Yeah, I think as a profession, HR people forget that we, as our employees as well, and even though we have more responsibilities than the average employee, we still have the same rights.
Yeah. And I think sometimes we forget that, right? Because we are agents of the company. We are working on behalf of the company, but we have rights too. And so again, as you listening to this, listeners, I know we have a lot of HR professionals listening to this. Think about your rights. Are your rights being trampled on? And if they are, what are you going to do about it, right? And so kind of taking about that as well. All right, so I wanted to talk about a story, start off with a story that I just read about employees' rights were taken away. In this case, I'm going to say it's wage theft, but I want you to decide, Chuck, after I've told the story, whether you think it's wage theft as well. And so this takes place in in the city of, listen to this, Chuck, the city of Grapevine, Texas. And it takes place in a winery.
Oh, I love that.
In Grapevine, Texas.
I love that.
So it's a very descriptive town there. So the winery was collecting all employee tips, and then they would pay them out to all employees as quarterly bonus. So a waiter or staff member would receive a tip, and it would be put into a large pool. And then every quarter, the manager, the owner, would give the tips out to all employees, even those that were not typically eligible for tipping, like managers.
Yeah. So while that may sound generous and that may sound nice to do, the Department of Labor Wage and Hour Division would probably think that sounds like wage theft.
Yeah, right. And that's what they agreed, right? The Wage and Hour Division came in. In fact, what was happening because of this practice, many of the employees were not meeting minimum wage.
Yeah. So it's important to know that even if they're being paid a tipped rate, they still need to make that minimum wage, whether it's the national minimum wage or many times the state minimum wages. But the company has, if not, the company has to pay the difference in what's called the tip credit.
Yeah, right. And so let's break this down. So if I work at a restaurant and we have a slow night and I get $15 in tips plus my $2.13 an hour, and I worked a 6-hour shift, I would have made $27.78. When for me to make minimum wage at $7.25, right, the federal minimum wage, I would have had made at least $43.50. The restaurant then would owe me $15.72, right?
Yeah. Usually, though, it would be calculated per pay period. So it's possible you could have a slow night and then a busy weekend, and the restaurant would be covered if during that week you ended up being above that threshold. But as a note, as a reminder, and I think a lot of our listeners know, be aware that tipping wages are different by state. For instance, in Florida, the minimum wage is $11 an hour, and the tip wage is $7.98 an hour.
Yeah, right. So that's kind of interesting. And then it's a really good reminder, I think, this conversation, Chuck, that employees have the right to minimum wage, which can be set by not only federally at $7.25, but can also be set by the state or the local community as well, right? And so to finish this story, the other thing the winery did wrong was not calculate the regular rate properly.
Yeah, so that's something that gets people tripped up all the time. Folks, the regular rate, and if you want to put a capital R and a capital R, because that is a term, the regular rate is the employee's hourly wage times the number of hours worked, plus any non-discretionary bonuses they received, divided by the number of hours worked. Boy, that sounds so complicated, but it is true. When I say discretionary, non-discretionary, it could be tips, it could be sales commissions, anything along those lines.
Yeah, right. All those things are in there. They did issue. It's coming back to me. The Wage and Hour Division did and it was December of 2019. I'm going back, Chuck. Check that memory out. They issued a fact sheet about what their final ruling of those things that were excluded from the regular rate. So if you want to go look that up, that's a fact sheet that may be beneficial. And I love that you capitalize those, Chuck, right? Because I think a lot of times people hear, oh, they get 1.5 times their regular rate, right? For overtime, 1.5 times the regular rate. Oh, that's their hourly rate. And it's not, right? And so again, employees, when companies are calculating your overtime rate, it's based on your regular rate. So if during that pay period, you got a bonus, you got a commission, that would be included in that, right? It should be included in that calculation. And so I just see so many times organizations forget to include bonuses when calculating the regular rate for overtime purposes. I'm trying to think. There was a story. Oh, Giant Food Stores did this early on during COVID, where they were giving everyone a hazardous pay bonus every week, and they forgot to include that in calculating people's overtime, and so they got in a little trouble. Had to go back and recalculate that there.
Yeah. So you're talking about overtime, and hey, wait, that's another employee right, correct? To be properly classified under the Fair Labor Standards Act.
Yeah, you got it, right? Under the Fair Labor Standard Act, only certain individuals can be labeled exempt from overtime.
Yeah. So how does an employee know if they are non-exempt? In other words, how do they know they should be getting overtime pay?
Yeah, and it's complicated, right? You and I will sit down with HR professionals and we'll walk them through the process of making sure they're properly classifying non-exempt employees and exempt employees. One of the things that we love to do is to go to organizations and do an audit of your FLSA status, right? So we know, all right, this is it. And so I want to kind of give the best thing for an employee to do is to sit down with your human resources rep. They don't bite. I am telling you, they are good people. They are there to help you. So sit down and ask them, hey, can you explain to me why I am classified as a non-exempt employee or why I'm classified as an exempt employee? They should be able to clearly define that for you.
Yeah. So, yeah, is this a challenge, you think, for our listeners?
No, I'm not challenging them because I think our HR professionals, right, should know how to do that, and more importantly, should know how to communicate to the employees why they're exempt and why they're non-exempt, right? They should be able to do that. I know that there. But for employees who are listening today, let me review the process to you. And it's going to get into a little bit of detail, but I think that will do it because as I said, Chuck and I will go to a company, and when we go to a company and we're going to do this audit, right? We're going to do the audit of the Fair Labor Standard Act exempt and non-exempt status. The first thing we ask is, are your job descriptions up to date? And so one of the things as employees, you should be reviewing your job description and making sure that there are no changes that have been made in your job description, right? Make sure that's there. And so once we have that up-to-date job description, the first thing we do is we look at a person's or individual's salary level. Mm-hmm. You cannot be exempt if your salary level is below the federal or the state minimum exempt salary level, which is presently set federally at $684 per week. In California, I think it's around 64,000. Colorado, it's around 45. Maine, it's around 41. I'm missing one state. So that's the first thing, right? So does that make anything else I need to explain there, Chuck?
No. And that is as of this recording, August of 2023. We may see that go up. And actually, John, we were supposed to see that go up this summer. Some people are saying that threshold was going to go up another couple $100. So we shall see. But you got it correct.
Yeah,
on that
and
one.
we're waiting with bated breath for the Department of Labor Wage and Hour Division to release that new number. There will be public comment, and then we think, right, we're the rumor gossip is that will be in law January 1st. So it's something for all of us HR professionals to pay attention to.
Yeah.
All right, so that's the first thing, right? We have to go through four different things to see whether, or three different things to see whether you're exempt or not. So that's the first thing. So if your salary is below $684 a week, you should be non-exempt. The second thing is to be considered exempt, your salary can't fluctuate based on the quality and quantity of work, meaning that every pay period, you should get the same base salary.
Yeah.
So it should not fluctuate every week, right? And then finally, what we do in our audits, we'll look at your job description and compare it to the job duties of the exemptions that the Fair Labor Standard Act has created. And if they match, then you would be exempt.
Yes.
If not, then you probably would be non-exempt. And this is where it gets complicated because there are many different exceptions to this rule that are not as clear cut, right? And so that's why I can't say to you, yes, you're definitely exempt or non-exempt until we do an audit. We find out what industry you're working at, what state you're working at. But those are the basic parameters on there.
Yeah. The job duties definitely gets people tripped up, clients that I've worked with, companies that I've worked with. And so making sure those job duties are in line and meet the standards to be exempt. Well, what if an employee talks to their HR manager or professional in the company and they still disagree? What do you recommend? What's the next step?
Yeah, and so there's a couple things that you can do. The one thing you can do is reach out to the Wage and Hour Division and submit a claim. Go to the Department of Labor Wage and Hour Division page, and you'll see a place to put in your complaint. Or you can reach out to an employment lawyer and discuss the situation with them. My first piece of advice is to see how other people in your organization are being treated. Is your FLSA status different from than similarly situated employees, i.e., people are in the same position? So if you're in a department and there's 3 or 4 of you with the same job title, and you're exempt and they're non-exempt, I'm going to question that. I'm going to question that and kind of see what's going on. And if the HR professional can't explain the difference, I would definitely then reach out to somebody on there.
Yeah. Yeah. And I just want to throw out one more thing. A lot of times people are excited to be classified as exempt. Oh, look at me. Maybe I've made it. I'm, right. And they turned me exempt. They turned me salaried. I'm a salaried employee. However, you may be leaving money on the table because really you could still be eligible and maybe should still be an hourly non-exempt employee, and you're losing out on overtime. So it's really important for employees to look at this, and obviously your HR folks to look at it also to make sure you're not fined and penalized.
Yeah. I always say is that in this day and age, the exempt status, and I don't know, maybe you disagree with me, but the exempt status really only serves the employer, right? There's nothing beneficial if you're an exempt employee. You get to work more hours, right? I mean, I don't know. Do you see anything in there?
No, I see it. I see exactly what you mean there.
Yeah, I think it's, again, back in the day, back when the FLSA was written, back in 1938, exempt was different. You typically got benefits where the non-exempt employees, you got the company car, you got the corner office, right? There was some status that went with it, not so much today.
Yeah, exactly. So, when we're talking about, talk to my HR professional, talk to other folks, I would have to reveal sometimes how much I'm being paid. Can I get in trouble for discussing my wages? In fact, what if I have something in my handbook that says, if you discuss your compensation, you will be terminated?
Right? Yeah. I love that you're moving the conversation along. I love that you're doing that. Yeah. So under the National Labor Relations Act, Coworkers are allowed to have conversations about their salary, their work environment, even their boss are allowed to have that.
Yeah, that term, protected concerted activities, which says that coworkers can work together to deal with work-related issues by talking to one or more coworkers. They can talk about their wages and benefits, their working conditions. That's all protected activities. Even circulating a petition, asking for better hours, participating in maybe a concerted refusal, say, hey, this is an unsafe work condition, etc. And the employer cannot discharge, discipline, or threaten you for asking, I guess, questions about any of these activities. Like, you cannot be terminated for these things.
Right, yeah. And so did you hear it, Chuck?
What's that? I'm listening. What?
Listen quietly. Do you hear it? The HR professionals in the audiences are groaning.
Yeah.
Right? Because it's an important right. And we as HR professionals must respect that our employees have that right. But how many times have you gone to the organization, or have you read the employee handbook and it says, employees are not allowed to talk about their salaries. If they do, they will be terminated. That's not true.
Yeah.
And then we get into a lot of whole lawsuits and all that kind of stuff. And so we have to make sure we're paying attention to that.
Yeah. Agreed.
Yeah. And I also want to throw out, I'm going to go off a little bit here, Chuck, but I was just reading an article about how the National Labor Relations Board is putting more strength behind how we're writing our policies. So if an employee cannot clearly understand that they have these rights, then that policy may be out of date, right? And so you want to make sure that you're clearly saying that any of this policies are not to oversee National Labor Relations Board Section 7, right? And so you want to be really careful about how you're wording your policies. There's going to be more coming out of this over the next couple of months, but I'm just throwing it out there so people are kind of thinking about what does that really mean in terms of how I'm writing my policies. Sure.
So where did we go from here, John?
Well, so I'm doing my research on employee rights because I wanted to make sure, and there are so many, but I wanted to concentrate on the ones that most violated by businesses across the United States.
Okay. So if you can allow me to just recap for myself and for our, for our listeners, we're talking about paying employees minimum wage. We talked about tipped employees and how you should still be receiving a minimum wage. We talk about making sure that non-exempt employees are truly non-exempt, and we are getting overtime after working 40 hours. And we did talk about protected concerted activities. So I count 5 things. Wow.
We covered a lot, right? Yeah. As a reminder, when we're talking about overtime, that varies by state as well, right? And so if I have employees, let's say California, we know that in California, people can get overtime after 8 hours in a working day, 40 hours in a work week, 6 days in a row. And don't even get me started, California also has double time as well.
Wow. Well, I think that's an important distinction that employees need to know.
What is that distinction?
Yeah. Well, not only does your business need to follow federal law, but it also has to follow state and local laws as well.
I agree. So what would be another, other than minimum wage, what would be a good example where states have different policies?
Yeah, sure. So there are so many. You know, I think one that comes to mind is required work breaks. Federally, there's no requirements for work breaks. However, if an employee chooses to do so, if they are 20 minutes or less, they have to be paid. If they're over 30 minutes, they don't have to be paid. Another comes to mind is child labor laws. The federal child labor laws are out there. They're fairly broad, specific but broad. But some states have tougher child labor laws, like here in Florida.
I think that's great. I think that's a really good example. And let's do this, Chuck. Samantha's in my ear. She's telling me that we should probably take another break. We've really given them a lot of information. So let's do another quick break. And then when we come back, I want to talk about what's happening in Tennessee in terms of breaks. And then we'll dive into some more employee rights as well.
Yeah, good old Rocky Top, Tennessee. Rocky Top, Tennessee. And with that,
gentlemen, you're listening to the HR Stories podcast, where there is a lesson in every story.
And maybe a song.
Maybe a song. Thank you. Okay.
Hello, listeners. I have some questions for you. Do you find yourself struggling with HR and employment issues? Are you afraid you could make the wrong employment decision that will cost your company thousands or even millions of dollars? Maybe you're new to the world of HR, or you've been in HR for a while and you just wish you had one resource, a guide to help you get HR right. Well, I've got good news for you. The team at HR Stories is excited to announce a new comprehensive resource, the Ultimate Book of HR Checklists. We created the Ultimate Book of HR Checklists as a simple, step-by-step resource guide packed with 70 downloadable checklists and other resources that help small businesses and organizations get human resources right. Even with very little HR or management experience, you can get instant results with concise, practical steps for addressing many of your tough employment issues. Do not miss out. Go to hrchecklist.com to learn more. That's hrchecklists with an S.com to learn more. And as always, thanks for listening to the HR Stories podcast, where the lesson is always in the story. Welcome back to the HR Stories podcast, where there is a lesson in every story. Today, we are talking about employee rights. We are all employees, and we've talked about 5 employee rights so far, and now we're going to continue talking about a 6th one, and John's going to tell us a little bit about what's going on in Tennessee.
Yeah, before I do that, I just want to remind everybody that if you go to our website, the team at hrstories.com, and look at our resources, the Ultimate Book of HR Checklists is going to help us HR professionals get HR right. It's also something maybe as a employee you want to check out as well. I definitely recommend it to my supervisors and managers because it gives us a process to use when maybe we don't have a strong HR department or we're not sure what to do in that particular case. So I just wanted to throw that out, Chuck, just making sure that people know that and are aware that resource is available to them. And we are having a summer sale, which is going to be ending in the middle of September sometime. So just to kind of be aware of that.
Perfecto.
All right, so let's go back to my home state of Tennessee, right? And so when we were right before the break, we were talking about breaks, bop, bop, boom. In Tennessee, an employee who works 6+ hours must be given a 30-minute break from work. So sometime in that period, they need to get a 30-minute break from work. In Oregon, employees get a 10-minute break for every 4 hours or greater part of 4 hours, and get a 30-minute lunch break after 6 hours of work, right? And so knowing your state law is really important to make sure you do that. What other state laws, what other would be another example of state law?
Sure. Another example of state laws is what companies can deduct from an employee's paycheck and when they have to be paid. Did you know that in Connecticut, for example, you cannot deduct damages or lost property from an employee's paycheck unless the employee has signed a form by the Connecticut Department of Labor?
So you can deduct it, but there has to be a process involved.
Yes, correct. And for our HR professionals that we haven't scared off yet, and as you talked about this, the Ultimate Book of HR Checklist does provide systematic approach to those HR challenges, your HR challenges, and gives you that information to get HR right. So I just want to do another plug for the hrchecklists.com. Go check it out.
Yeah, oh God, sorry about that. We're kind of doubling down on that. But I just do love a good checklist. And I think what I have realized is that for a lot of us, there are many issues. So a lot of us HR professionals, even employees, even managers, that we don't have to, there's issues that come up, but we don't have to deal with a lot. But when we do, it's important that we get it right. And so I love using the HR checklist book when I have to address an issue that I haven't had to deal with in a while. I think about this all the time because there are sometimes a client will reach out to me and I'll be like, gosh, I haven't dealt with that in a while. And then I'm like, oh, well, let's go back to the book. Let's go through the checklist. And it refreshes my mind. It reminds me of what we need to do. So it's always good to have somebody able to remind me of those steps that I need to take. I think it saves on my brain power, which you know, Chuck, is kind of limited.
Oh, no. You've got an immense brain. I call you Mega Mind. Except you don't have that blue colored skin like Megamind, but you're genius like that. But I will tell you, when you talk about systematic approaches, for instance, maybe sexual harassment investigations.
Is that your hint to move us along?
Yeah, I think so. I think so. So boom.
All right, that's good. Well, employees do have a right, and I quote from the Equal Employment Opportunity Commission website, employees have a right not to be harassed or discriminated against, treated less favorably because of their race, color, religion, sex, including pregnancy, sexual orientation, or gender identity, national origin, disability, age, 40 or over, or genetic information, including family medical history.
Sure. So what would be an example of illegal sexual harassment for some of our newbie listeners?
Well, if you haven't listened to episode 45, Chuck does a great job of breaking down third-party harassment where a union representative harasses a supervisor from the UPS. Right. And so it's such a great example. So go back and listen to that episode. I think it really help you kind of do that.
Yeah, that's a good example. Listeners, listen to that. Highly recommend. You're going to find a lot of information about protecting your organization against a potential lawsuit.
Yeah, I think that's good. Employees also have a right to religious accommodation. For example, if an employee has a sincerely held belief that they have to wear certain religious garb, right? So clothing or dress that my company then has to allow it unless it would cause an undue hardship.
Yeah, that's the key there, that undue hardship. Can you give us a more specific example on that one?
Can I use an old podcast or do you want a new example?
I'm going to test you and maybe say a new one, but we did cover this. One of my favorite early episodes, the tale of the beard and the applicant, back in October 2020. It's still a great episode, still very relevant today, but let's see if we got a new one out there, John.
All right, you're pulling at me. You're asking me to go in there and go, okay, what have I been reading and thinking about? But here, I have one for you. All right, so there's a recent story. There was a gentleman in Reston, Virginia, who worked for a company that provides protective services to federal agency, so not far outside of D.C. One of the dress code requirements was for all male employees to be clean shaven, no beard. He, though, had a sincerely held belief that as a Christian male, that he must wear a beard, or must have a beard, I guess not wear. He reached out to the EOC and sued the company. This case is still pending, but it rests on the words sincerely held belief because he didn't have any supporting documentation from a religious leader. As he was not part of a organized religion, it will be interesting to kind of see where that goes. And we will, of course, provide updates and that kind of stuff. But so he was a Christian male who believed that he needed to wear a beard, but was not part of sincerely held religious belief that he should have a beard. But he wasn't part of any organized religion. And typically the company would go and say, well, I need a note from your religious leader saying that you have this sincerely held belief. So it's going to be interesting to see where that goes.
Yeah. I saw a statistic today, actually, that religious complaints to the EEOC shot up like 650% over the past year. So, and a lot of that had to do maybe with COVID and vaccines and a number of things. But I found that to be interesting, and I'll be really interested to hear the outcome of that case. So we will follow it. But that does lead me to another right that employees have under more than 20 different states and 40 local governments. And I'd have to say it's even up to 23 or 20 states, 23 states now. Companies cannot allow discrimination based on hairstyle and texture.
So what would an employee do if they are feeling they are being discriminated based on their hairstyle?
Yeah, so talk to HR again, discuss your concerns. But the other thing they can do is, and this is the term for this, John, there's the laws that they're putting through are called the Crown Act. And we did an episode on this, but there is an official webpage on the Crown Act. Just search Crown Act and you'll see there are a lot of resources available.
Yeah, and I love that Dove, the Dove soap company, is a major sponsor of that. I mean, it's beautiful branding, but I love that they're throwing their might behind this right. I love that they're doing that.
Yeah, that's really something. It really is. And I was surprised to see a big giant corporation backing the Crown Act. I will tell you one thing that I did read recently is that this summer there's another push to get it through the federal channels again. And I know they tried a couple years ago. It got shot down. So they've retweaked it a little bit. One of the big tweaks that they put in there is about safety. So there were some interesting things. But yes, I do agree with you on a lot of that.
That's cool. Okay, so we've taken a lot of time today to talk about the rights of employees.
Yeah, but we've only touched the surface. You know, I really think we need to continue the conversation.
That's great. I'm up for it. Let's plan on diving into more employee rights in our next episode.
Yeah, sure. Employees and HR professionals, make sure you tune in our next episode. I like this theme. I like where we're going. We're going to be talking more about employee rights, what HR can do to protect them, but ultimately, by protecting employee rights, you are protecting your company. But remember, employment laws were written to protect employees, not protect companies. If you violate them, your company could be exposed and in jeopardy.
You have been listening to the HR Stories podcast, where there is a lesson in every story. Please don't hesitate to reach out to us at team@hrstories.com, where we help HR departments succeed. Thanks for listening, everyone. Thank you for listening to the HR Stories podcast. The material presented in this podcast is for informational purposes only. Chuck and John always recommend using an employment lawyer or HR consultant to handle any legal concerns or HR issues. We do our best to double check sources and make sure the information we are providing is accurate. We may eliminate or embellish without changing the basic narrative to make the story easier to understand. In certain circumstances, we may change identifying information to protect the innocent. The HR Stories broadcast is brought to you by the team at HR Stories. The team at HR Stories is designed to help anyone with HR responsibilities be better at managing the employee experience. To engage with us, go to the hrstoriesteam.com and learn more about how the team at HR Stories can support your business or nonprofit. Thank you for listening to the HR Stories podcast, where there is a lesson in every story.